I think everyone is ready, so please continue, Mr. Braven.
Thank you very much. Mr. Polo, let me show you Article 2 of the mining regulations. The mining regulations are in tab 22, CA 432.
Okay, está bien.
That's fine.
Do you see them? And I wanted to refer you to Article 2 of the Mining Stability Regulations. Now, let me ask you first, is there any, you discuss the Mining Stability Regulations in your witness statements. Is there any particular reason why you omitted to mention Article 2 of the Mining Stability Regulations?
Not as far as I recall.
Okay, let's take a look at them. So the first paragraph says, I'm going to read the English. You have the Spanish on the screen in what looks like the original print. The provisions contained in Title 9 of the Single Unified Text, let's stop here for a second. The provisions contained in Title 9 of the Single Unified Text, those are the provisions dealing with stability guarantees, correct?
That's right.
Shall apply as of right to all mining activity title holders, and then it defines them as the natural or legal persons that perform mining activities in a concession or in concessions grouped in an economic administrative unit as title holders or assignees, provided they fulfill certain requirements. You see that?
Sí.
Yes.
So that provision doesn't refer to investment projects, does it?
No.
Provisions of Title 9 apply to legal persons that perform mining activities in a concession or economic administrative unit, correct?
Let me think. Okay. Yes.
When I'm referring now to the last paragraph of Article 2, when the natural or legal person is the title holder of several concessions or economic administrative units, the qualification will only take effect for those concessions or units that are supported by the declarations or by the agreement referred to in this article. Do you see that?
Yes. Could you show it a little higher up?
No, si pueden.
I just ask if you can bring up the whole paragraph.
Do you have the provision in front of you and in the binder as well?
¿Qué número era el 22?
What number? 22?
El
Number
artículo
2.
2, pero la pestaña.
Article 2, but was it tab 22? 22.
Ya. Estos números, las letras son muy chiquitas, ¿eh?
It's very small font. So you're telling me, okay, where it begins with natural persons.
So, would you agree with me that what it is saying is that a mining company has several concessions or economic administrative unit? The stability guarantees will only take effect for those concessions or units that are supported by the stability agreement.
It cannot be so interpreted because a supreme decree does not change the statute law. It must refer to something else. I did not draw up this regulation. I did not participate in it. I understand that it must refer to those things as long as they are not at odds with the law, statute law. This is called the Kelson Pyramid or something like that. But understand that statutes prevail over supreme decrees, and therefore this D, if you want it to be understood that the concessions or economic administrative units have a stability for them, that cannot be, because that would contradict what the law says. And one must read it differently, I imagine. That is, it cannot contradict the law.
Mr. Polo, the mining stability regulations were prepared by Minim, right?
Yes, I suppose so, when I was not there.
Know whether they were prepared
Yo
by
no
Minim?
estaba allí.
I wasn't there.
Them in your witness statement. Do you know whether they were prepared by Minim?
Sí, claro.
Yes, of course, they must be prepared by Minim, but a supreme decree implies that it would be approved. Well, I think it's with a vote by the Council of Ministers, because it's also signed by the Minister of Economy, the Minister of Energy and Mines, and the person in charge of the office of the President of the Republic. So it's a supreme decree, but it is lower in rank than a law of the Republic.
So, are you telling us that what is written here in Article 2 is contrary to what is written, what the mining law provides?
I'm thinking it depends on how you wish to interpret it. If you wish to interpret it as though the economic administrative units and concessions have stability agreements, that it's for them, then that would be against the mining law and it would not be valid. So the only way to interpret it is to read it systematically with everything, and you'd have to read the entirety of the regulation, and the regulation in several articles, 22, 25, and several of them refer to the studies, the feasibility studies, which are the basis for the stability agreement. So everywhere it says, as long as it is consistent with the law. So I understand, I might be mistaken, that you are suggesting that those who have stability agreements are the economic administrative units or the concessions. And that cannot be, plus the regulation itself has to be read in several parts where it is given to be understood that that cannot be.
Mr. Polo, I understood you as making sort of two arguments. The first one is that you said, well, let's take the first proposition, which is that what is written in Article 2 is contrary to what the law says, and then I will take you to the second one, which is it has to be interpreted in accordance with the law. So let me start with the first one, the contrary to the law. Are you aware of any decision by a Peruvian court declaring Article 2 of the mining stability regulations, or any other article of the mining stability regulations as invalid? Are you aware of any such decision?
No, because I understand that one can interpret it in a manner different from what you are suggesting.
And coming now to the second part, where I said it should be interpreted a different one, is it your testimony that people in Minim made a mistake by writing concessions and economic administrative units when they should have written investment project set forth in the feasibility study? Is that your testimony?
I'd have to read it now, but what I have read of the regulation, I have reviewed it on several occasions, it speaks of a sort of location. That is to say, the meaning of saying the concession of the economic administrative unit, they use it so as to say there, where the investments are. That is where the investments are, but not with the meaning that the concessions or the economic administrative units have the stability. They don't say it anywhere. Indeed, at Article 22, if I remember well, it repeats once again what Article 7 and 11 of Decree Law 708 say, where there is talk of investments in the economic administrative units or in the concession, something like that. We can read Article 22.
We will get to Article 22. But right now, it doesn't say in the concessions, it doesn't say investment in the concession. It says will take effect for those concessions and economic administrative units. Para, in Spanish. Para las concesiones. Doesn't it?
Yes, but the provisions have to be interpreted in an integral, systematic manner.
Is that the reason that you omitted it from your witness statement when you discussed the scope of stability guarantees in the regulations?
No. For me, everything is so clear throughout the regulation that I didn't pick up on the fact that that might be a contradiction. But since you're suggesting it and very much limited to that subparagraph of the article or that paragraph of the article, well, there I have to say that that is not the case.
Let's take a look. I think you mentioned Article 22. So let's take a look at Article 22 of the mining stability regulations.
Sí.
Article 22 says in the English version, the contractual guarantees shall benefit the mining activity title holders exclusively for the investment that it makes in the concessions or economic administrative units. And then it goes on to say, to determine the results of its operations, a mining activity title holder that has other concessions or economic administrative units shall keep independent accounts and reflect them in separate earnings statements. Do you see that?
Sí.
Yes. And it says what I said.
Is there any reason why you omitted the second paragraph of Article 22 when you were discussing Article 22 in your witness statement? First witness statement, paragraph 33.
No.
No, not at all. For me, it's clear. It says exclusively. By saying exclusively, you're saying that is totally determined and separated. Exclusively, and that are situated in the concessions or economic administrative units. Actually, one can accept that it is in, but let us bear in mind that in is talking about the delimitation. So, or exclusively for the investments, the investment project. Investment or investment project is the same thing. The investments that are situated in, nowhere does it say that the concessions themselves have the right, so as to follow down the line that you were pointing to.
Mr. Polo, it says investments that it makes in the concession and economic administrative unit. So first of all, it doesn't say investment project, it says investments, doesn't it?
Bueno, pero
Well, investment is the same as an investment project. Investments are made through investment projects, and it says in, yes, in that place. In, as in a place.
Investment project is a single investment. Here it talks for, it doesn't qualify by number the investments. It says for the investments that it makes in the concessions. Isn't that what is written here?
lo que dice, las garantías contractuales beneficiarán, las garantías contractuales.
It says the contractual guarantees, that is to say, those that are established in the contract, shall benefit the mining activity title holder exclusively for the investments that it makes in the concessions or economic administrative units. Those are the guarantees that are in the agreement. The agreement is for the investment project and the investments. Otherwise, you could tell me it's all the investments that they have. Well, why have a stability agreement if they already have it? Excuse me, please. I'd like to conclude. The word exclusively is very clear, and it refers to the contractual guarantees. That is to say, the stability agreement. And the part referring to the concessions and economic administrative units is a reference to the place. It's situating them, determining they're in a particular place.
Mr. Polo, we agree that not all investments are covered, that the exclusivity distinguishes it, but the distinction is drawn in the second paragraph that you omitted from your witness statement, isn't it? The second paragraph says, if you have several concessions or economic administrative units, some of them stabilized, others not, you have to reflect them in separate accounts. Do you see that?
Yes, I do see it.
It doesn't say that you have to keep separate account for different specific investment projects set forth in different feasibility studies. That's not what it says. Does it?
No, no dice eso.
No, it doesn't say that there. It doesn't say that exactly, but it says to determine the results of its operations, a mining title holder that has other, you have to look at all of its operations that it has, and that has other concessions or economic administrative units shall keep independent accounts and reflect them in separate earnings statements. Well, to begin with, the accounts aren't divided by concession or in economic administrative unit, rather by company. So what they're saying is that there need to be earning statements that are separate for what is stabilized and for what is not stabilized. And there are several articles that go to that same point. Article 25, for example. I did not participate in drafting this Supreme decree. I understand they've wanted to put it in certain things, but it can't change what the law says because it's a Supreme decree.
Sí, señor.
Let's stay with the topic, but let's look at a specific event, and one that Madam President has referred to, which is the March 2004 Royalty Forum. So you participated in a forum, the forum that we know as the March 2004 Royalty Forum, which in March 11, 2004, correct?
If the March 2004 Royalties Forum was the 11th, that I no longer recall.
Just so that we know what we are talking about, that was a forum organized by Peru's Congress organized by Peru's Congress, right?
Sí, es correcto.
Yes, that is right.
The topic, the reason it's called Royalty Forum is that at that time, Congress was debating a royalty law, but in March 2004, the royalty law was not yet passed, right?
That is right.
And the royalty law would eventually be signed into law in June of 2004 of that year, right?
That is right.
And that was a forum that was closed to the public, right?
It was held in Congress, where the people who were at Congress were there, members of Congress and their aides. It wasn't closed in terms of being a secret or secretive.
And you attended that forum on behalf of Minim, right?
Yes, that's right. I was still vice minister at that time, and I went representing the ministry. The minister must have told me to go.
And you actually gave a presentation at that forum, right?
That is right.
And the presentation was entitled Evaluation of the Application of Royalties in Peru, right?
I don't remember the title, but in one part there's a comparative analysis on the effects of royalties, and in another part I spoke specifically to the situation of royalties with not so much the projects but the companies. So there were different parts. One was about the advisability or the lack thereof of adopting royalties. I had some misgivings about the adoption of royalties.
Oh, I got it. So you had some reservations regarding the adoption of mining royalties.
Claro,
Yes. In that context, with those prices, my concern was that a royalty, such as was being proposed, applied blindly to the sales cost, could affect Peru's competitiveness vis-a-vis other mining jurisdictions. And I made a presentation looking at the different considerations.
Were you the only person in the government who had concerns about the royalty law at that time?
Let's say I was the one who led the concern, and as far as I recall, Maria Chapuis preferred to abstain from or refrain from participating in that discussion. As far as I recall, many years have passed, and it's likely that Osvaldo Tovar helped me out with the graphs and tables. I said, show it to me with royalties, without royalties, how the position might shift. That's what I was doing with the people who worked with me.
Do you recall the position of the Ministry of Economy and Finance? Were they in favor or against the adoption of the royalty law?
Well, first of all, they were the ones who hired the expert to analyze the issue of royalties, Mr. Otto. And I thought it was fine for them to call him in. And he proposed imposing royalties of up to 2% and not anything more, because that was hazardous, but on recommending that it be offset with another way of, well, looking at duties or other factors, I don't remember so well, and it's on the basis of that study that I looked at I used his data and I presented tables, and because what he was doing was a sensitivity analysis. So taking advantage of the sensitivity analysis, I put up the royalties and how the table would vary. That's what I did, and I expressed my concern about the loss of competitiveness that might ensue.
When you mention Otto, are you referring to Professor Jim Otto, who appears as an expert in this arbitration?
sí,
Yes.
So in your, is it correct to say that in your presentation you also addressed the impact that existing stability agreements would have on a royalty law?
así.
Yes, I was very clear about that royalties would not apply to investment projects that had stability agreements. We maintained that position very clearly.
Muy claro.
So the position of Minim at that time was that stability agreements are to be respected, and if to the extent that companies are covered by stability guarantees, mining royalties should not apply. Is that correct?
Let me correct. It's not the companies that are protected, it's the projects that are protected, and to that extent they should not apply. The companies is much more.
That clear a few times today. So let's look at the presentation. I think you mentioned also that you used PowerPoint, right?
Yes, I presented a PowerPoint and looking at the movements with the royalties and so forth.
And you
Yes?
helped prepare. I think I heard you say you helped prepare that PowerPoint. Is that correct?
I asked that they do the PowerPoint for me with certain specifications. I wanted the PowerPoint to be based on the tables of James Otto, and to apply to that as part of the report the sensitivity analysis with a varying royalty to see how Peru's competitive position would vary.
We will discuss the. My question was, did you did you prepare that PowerPoint?
Yo diría,
I had it prepared. That would be the clearest response. I had it prepared for me.
You mentioned that Mr. Tovar helped you with the preparation of the PowerPoint. Did you say that?
Yes, of course. He handled much better than I did the tables, computers, and all of that. So I said, prepare something.
And I imagine, being a diligent person, you reviewed the PowerPoint before you gave the presentation, right?
Yes, of course. I had to review it.
Let's look what you said in the presentation with regard to the PowerPoint, and we have the transcript of that presentation, and the transcript is CE 1137, which is in tab 3. Tab 3? No. Tab 17. I'm completely off. Tab 17 of your binder.
es un segundito.
Just a second.
En el 17 me dice usted.
Did you tell me 17?
17. And we're going to put it on the screen as well. I put the relevant part where you address the topic on the screen.
Es solo transcripción.
Just written transcript, right?
Then we're going to look at the graphics, okay? So that's the transcript of the session, and you said.
Página.
Page?
Slide. Sorry, it's not slide. It's page. Which page is that? Page 13 in Spanish and
13.
page 4 in English. Yeah, 13 in Spanish and 4 in English. And you say, let us take a look at the stabilization agreements, please. I'm reading from the screen. That's where the companies are. Stabilization agreement are not given on a company basis. That's important to clarify. A company can have a stabilization agreement for one project and not have it for another, or have an old activity that does not have a stability agreement and a new one that does. It's not given to the company as a whole. And then you say, therefore, and here are more or less the periods between which the companies would be. Sorry, did I? It's not given to the company as a whole. An investment of over 20 million or over 50 million is made, as the case may be, and that gives the company the right to stability for that particular investment, for that development, not the whole company. Therefore, and here are more or less the periods between which the companies would be subjected to royalties or not. And in the following chart, you will see more or less what would be the spectrum that would be subjected to the royalties. So what you're basically referring here to, you say stability is not granted to the company as a whole, but to projects, right? And later on you call them investment and developments, right? You see that?
Correcto.
Correct. as you said, for that investment, not for another one, for a specific investment.
Word project. Project, mining project is often used to refer to mining units, right?
No. They're not synonyms. You can see that in any of the publications of the mining investment portfolio for 2021, 2022, 2023. They're going to see this is a portfolio for mining investment. The productive unit was the location of the project, and the management unit.
Let's look at the slide that you presented while you made those comments. And the slide is that C123? It's tab 18, CE 19.
Ya lo vi. Sí, está.
And it's slide number 10.
Correcto.
So you would
Correct.
agree with me, that is the slide that you were discussing when you made the comments and referred to the companies and the periods during which the agreements are effective, right?
Sí.
Yes, that's what it says. And you should read companies and also a unit, a mining unit.
You were referring to mining units, didn't you?
Sí,
Yes, the title of the PowerPoint is mining unit.
Projects, did you?
no, pues los proyectos están un poco.
No, because the projects are a little bit below. I said if I said mining unit, someone could get confused. May I answer the question?
So
Oh,
you did not refer to the investment project that it would be covered by stability guarantees when you're explaining what is exempted from what would be exempted from royalties, did you?
digamos que el gráfico no,
Let's say that the graph is not specific, but my words are even more precise, which I have already said very clearly.
Let's take a look at what it says here. Do you see Sociedad Minera Cerro Verde?
sí,
Yes?
It says under Unidad Minera Cerro Verde 1, 2, 3, and it doesn't say the leaching project, does it?
era el único que había.
That was the only one there was at that point. There was nothing else. There was no room for confusion.
Well, let's look, for instance, at Tintaya. It has its two mining units there. One, the oxides plant mining unit, and the other one, the Tintaya mining unit. Do you see that?
Sí, son dos proyectos distintos.
Yes, there are two different projects. The oxide plant is different from Tintaya, that is the Tintaya company, but it was back then Billington Tintaya. The oxide plant is a stabilized project that is different from the original Tintaya, but it was also stabilized. And it is stated in that fashion. There, those are projects. The Tokyo industrial plant is one.
Project?
El
The
segundo,
Tintaya, You're telling me that Tintaya is a specific investment project, Mr. Tovar, although it's entitled Unidad Minera?
El
As to the second project, I didn't know of it as a stability contract, but it is there as an industrial plant, and the other one may not. Altamina also says Altamina without any qualification, and so on and so forth. There is a mining unit that is explained there, and within a mining unit, it may have projects that have stability and that have that duration.
So, Mr. Polo, isn't it the case that in March 2004, when those slides were prepared, you clearly understood that stability agreements apply to mining units as it is set forth in Article 2 and 22 of the Mining Stability Regulations, didn't you?
jamás.
Never, never. And I have repeated this a million times at all the fora that I have attended everywhere. I must have also appeared before the Constitutional Tribunal, and I asked you, and you told me that you are aware of it. Given the question by Ms. Goredo, she asked me whether the concession was for the project. I said it several times. I understand that the graph may lead to a confusion, but the fact that I may change my opinion overnight is not my style unless I am convinced.
I was still with the translation, so you have no further questions?
I had no further questions.
Okay, thank you. Do you have questions on recross?
I think I may have a couple, but I just wanted to take a short break to confer.
I'm still here? Yes. Hablaremos de fútbol, pues. Yo soy de la Alianza, por si acaso, ¿eh?
Okay, we're ready. I have a couple of questions. Mr. Polo, do you recall when you were first being cross-examined and claimant's counsel had asked you how many hours you had spent preparing for the hearing, and you said 200 hours. Were you paid? Have you been paid for your testimony?
No.
No. That's my responsibility.
You were also asked by claimant's counsel about different terms, economic administrative unit and mining unit, and you said that they were different, and you were taken to Article 82 and Article 44 of the mining law to discuss the definition of EAU. Is the term mining unit defined in the mining law?
No recuerdo si en alguna.
I don't recall, but that is a typical use. That is the management unit, and the economic administrative unit is an abstraction to fulfill with the obligations of the rights granted to concessions that are put together to be complied with as obligations.
Such as the EAU, that where it's defined?
Sí, está definida.
Yes, it is defined. I don't recall. At 44, I think it is defined at 44 with an area of action. For example, you can group them together with within a determined area.
The economic administrative unit.
Sí, a la unidad económica.
Yes, the economic administrative unit.
Checked it that those were very leading questions, and that Ms. Howard is testifying here on the record instead of asking questions.
I disagree that that's the case. I was just asking a question. But I wanted to specify what was the precursor and what he was being discussed in a cross-examination in order to orient him to what the question was going to stem from, the discussion that they was having with claimant's counsel. You were just talking with claimant's counsel. Claimant's counsel was asking you certain questions with respect to the mining regulation, and in particular, Article 2 of the mining regulation. And I believe it's behind tab 22 in the binder in front of you. Do you recall that discussion?
Sí, sí, me las tuve.
Yes, I do.
And you said that to understand those articles, you needed to consider the entire mining regulation and the law. And you referred to Article 24 and 25 as supporting your understanding. Could you take a look at those two provisions and explain what you meant? Because you did not have a chance to discuss those two provisions.
I object to that because the cross was about Article 2 and 22, so
He mentioned
we
Article
can't, like,
24
we
and
can't, like, open up
25,
now
and
the
you didn't
entire
get a
mining
chance to
regulations
respond.
for the redirect. It has to be focused on the
Yeah.
provision that I discussed.
No, he mentioned Article 24 and 25 and didn't get an opportunity to provide the full answer with respect to those two provisions. So he is entitled to, is exactly what redirect is for.
Please go ahead.
Yes. So, Mr. Polo, you were asked about Article 2 and Article 22 of the mining regulations, and you said that you have to understand those articles and consider them an entire regulation and in the context of the law. And you referred to Article 24 and 25, but you didn't get a chance to discuss those. Could you please take a look at those articles and explain how those articles support your understanding of the scope of stabilization agreements?
Voy a leerlo.
Let me read them, right? The Directorate General of Mining shall submit to the Office of the Vice Minister of Mines the record and the directorial resolution approving the feasibility study or investment program, as the case may be, which will serve as the basis to determine the investments of the contract for the minutes, etc., according to Article 86 of the Single Unified Text of the General Mining Law. Article 25 5, without prejudice to the income and corporate assets tax returns, which, according to the law, the mining activity title holder must submit in cases of expansion of facilities or new investments that contractually enjoy the guarantee of legal stability, that is to say, expansions on investments that have stability clauses. Such title holder must make available to the tax administration the annexes that demonstrate the application of the tax regime granted to the aforementioned expansions or new investments. It is extremely clear.
But is now the investor needs to present its grounds now when he considers new investments as being stabilized. Is this what Article 25 is about?
No. That is correct in case of expansions. In the case of expansions, you will have projects that are governed by various regimes. And for example, if you're going to present one that is under a contract stability agreement, but not the other one, those demonstratives need to show, starting with the stability agreement that defines the project, they need to show how it has been developed year after year, what has to be paid, what they are exempt from, whether the tax is lower, whether the royalty won't be paid. For example, in the case instant, the intent was to charge royalties to everything. We said, no. What is left outside the stability agreement will pay royalties. So if you have a stability contract, you don't pay royalties, but you do if you do not have that agreement. So to the SUNAT, we told them these are our annexes that were approved with the feasibility study. This is not going to pay the royalties, but the rest will. And this goes beyond the income tax. And for SUNAT, you need all of these annexes so that it's exclusion, modification, whatever it is under the stability contract for that project requires. It is very simple when we decide to do this, because investors, when they make a decision on the feasibility study that is requested by the investors, they make a decision on the project, not on all of the company, and say, okay, we are going to invest 500 million in what? On what? This, and that, for example. That's the answer. I am going to look at the results, and then in that case, that is the feasibility study that will be approved and the one that will be controlled on a yearly basis. And that is separate from the existing operation or unit. So they need to be broken down because they apply exclusively to that. And that's the reason why the word exclusive is central. The exclusivity tells you that it cannot be everything. It's exclusive to this. It cannot be everything. If it was everything, it would say so. We would need to say exclusively.
Just one final question now from my side. In your first witness statement, you stated that title holders of mining activities may carry out one or several investment projects within the area of the concession. And in the second witness statement, you specifically refer as an example to southern Peru, where, according to your testimony, different stability regimes applied within one concession. So maybe we can pull back on screen this exhibit RE 175, to which Claimant's Counsel related to earlier. RE 175, this is a minimum, no, Counsel will do it, this is the minimum list of stability agreement in place when the, and there to this list to the very end. We already talked about it today.
Yeah.
So now let us look here to southern Peru.
¿Lo tengo yo en mi carpeta?
Do I have it in my binder?
Yes.
Por favor, ¿qué número es?
What number is it? What is the?
Del informe.
It is part of Mr. Isasi's report, I believe.
En el-
Carpeta 21.
ya.
Página 13, page 13.
Voy a ver el español para no...
Can we also put the English translation on screen and maybe highlight the line with, that concerns southern Peru and make it a little bit bigger?
Yo lo tengo en inglés.
Southern Peru, I think it's line 9. The company is named Southern Peru Limited. The project is named Electro Von Leaching. The investment was 118 million. And we also had this 15-year stabilization agreement. And it started in 1996, so something, I have no idea whether it's comparable, but at least some features may be comparable.
Sí, eso es así. O sea,
Do
no
you know-
conozco el proyecto.
Can you hear me? I am not familiar with the project. This is only in English here in my binder. 9 Southern Peru Limited. It says Lixiviación Electro 1. Electro 1 leaching. And that is that project. That project, I understand it is a project. It is to leach the remaining oxides from southern Peru that is perfectly identified with the stability period. It says 15 years. I didn't get to know directly that project. It was approved in 96 and it was implemented up to 2010, but I understand that it is the oxide leaching project belonging to Southern, and it is a project as such. Southern has a gigantic operation with other assets. They have Cuajón, Toquepala, so they have a different regime.
Referred in your second witness statement to southern Peru, specifically as an example of different stability regimes within one concession.
So from which paragraph is it?
It's paragraph 63 of his second witness
I'm
statement.
not sure that that's his. He doesn't have that long of a
Oh.
witness statement. So
Oh, then it would be then my apologies.
yeah, his goes only up to 36 in his second witness statement. Is it
Okay,
perhaps
then maybe
Mr. Tovar?
I have it wrong here on my list, and it was
Mr. Tovar, perhaps?
Isasi probably.
Or Isasi or Mr.
Yeah.
Tovar? Probably Mr.
Then I
Tovar.
withdraw my question. I'm sorry.
Sorry, just-
So I understand that you are not
No, no.
familiar with the project, so I will certainly not ask you any further questions on that. Sorry, that was my mistake. So no questions on my
No.
end? No. So, Ms.
Muchas gracias.
Yeah, you're released as a witness. Thank you very much.
¿Ya me puedo ir?
May I leave?
Gracias. Ha sido un placer todo esto. ¿Cierto? Es un placer.
So I suggest that we right away continue with the next witness, Mr. Tovar. Good afternoon, Mr. Tovar. You can sit down, yes. Just for council, for planning purposes, we also need to conclude today at 5:30, maybe a couple of minutes later, but around about 5:30, so that you know.
Noted. Thank you, Madam President.
We will start shortly. We just ask. Wait. Okay. No.
Madam President, this is the interpreter. I don't know if Mr. Tovar will listen to the interpretation. Can we test it if he's...
Mr. Tovar, will you testify in English?
His mic is off.
Good afternoon, ma'am, in Spanish, en español. Se escucha claramente.
I can hear the translation clearly. Okay. Thank you, ma'am.
Can we start? Okay. So, welcome, Mr. Tovar. I introduce the tribunal first. I'm here with my co-arbitrators, Professor Guido Tavil and Dr. Bernardo Cremades. My name is Inke Hanefeld. I'm the presiding arbitrator in this arbitration. You have been called as witness in the proceedings by the respondent, and because you will testify, you need out a declaration that you will testify the truth and nothing but the truth. So please be so kind to read out in Spanish the declaration that is in front of you.
Witness declaration. I solemnly declare, upon my honor and conscience, that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you. Do you have your two witness statements RWS 3 and 10 in front of you? Can you confirm?
I do.
Thank you. Can you confirm that these are your witness statements and that they correspond to your recollection, or do you have anything to amend or correct?
These are my statements, the ones that I had prepared and signed, and they are in order.
Okay, then we hand over to respondent for a brief direct.
Thank you, Madam President. I'll turn to Spanish with your permission.
Good afternoon, Mr. Tovar. Good afternoon, everyone. The witness statements that the President just asked you about are based on your experience and personal knowledge. Is that correct? Yes, that's correct. Please describe your academic background. I am a mines engineer from the Catholic University of Lima in Peru. I got my degree in 2001. After that, I did a Master of Sciences in Mineral Economics in the Colorado School of Mines in 2009. And I also have a diploma in Six Sigma in 2014 that I did in Peru, in Lima. What is your position currently? I'm currently a partner in 3 companies. One of them is devoted to mining consulting exclusively. Another one of my companies is a distributor and importer of medical equipment in Peru. And the third one is a contractor company, Construction Matters. What positions did you have in the government of Peru before the positions you occupy currently? Between January 2004 and September 2006, I was the director of mining promotion and development. It is a directorate. It was one of the directorates under the Vice Ministry of Mines in the Directorate of Mines. What were the roles and responsibilities that you had as the director of mining promotion and development? Generally, I had to promote the development of the mining industry in Peru in a sustainable manner. In particular, I recall that I managed and published production statistics and mining safety statistics. I provided opinions and I reviewed stability agreements, reinvestment of profits, explorations, concessions of beneficiations, mining plans, and the beginning of operations of new projects in Peru. What is a beneficiation concession? A beneficiation concession is a right. It is a title that the government grants as defined by the general mining law for a private party, an investor, to develop processing activities, beneficiation activities of mineral. This beneficiation concession, which is really a title, it's a piece of paper, is different from the investment that is made or will be made by the investor. The issuance of this title, the beneficiation concession, is granted by the state, and of course the investment is in the hands of the private investor. Thank you. In your witness statement, you talk about the expansion of the beneficiation concession asked by Sociedad Minera Cerro Verde in 2004. What is the relationship that exists between the application for the modification of the concession, of the beneficial concession, and the determination of the scope of the agreement? When I was at the ministry, I assessed and managed more than 50 applications for modification of a beneficial concession or for beneficial concessions. The processing of a beneficial concession never activated automatically any process that had to do with a stabilization agreement. So much so that when we looked at the list of all the procedures that were available at the MINEM, we identified that these were independent cases. They had independent requirements. They had different fees that had to be paid, different signatories, different terms for response. Well, these were different and independent procedures. What was the understanding of MINEM in connection with the scope of the mining stabilization agreements when you were working there? The understanding was cross-cutting and transparent and clear at all levels, at all management levels, and also throughout my tenure. The purpose of stability is not the company or the concession. It is exclusively the investment project that has been assessed by the investor itself as described in the feasibility study. That is why the law always asks for a submission of the feasibility study of the project that seeks stabilization. That has always been a clear position without any discussions while I was there at the ministry. Thank you. The DGM or the MINEM, have they ever provided to you a written confirmation, or rather provided Cerro Verde with a written confirmation that established that the primary sulfides project of Cerro Verde was included in the 1998 stabilization agreement for the leaching project? No, never. No written confirmation existed, and in none of the meetings that I was present at, there wasn't even a verbal confirmation. In some of the presentations made by the company itself, the company asked for the inclusion of the primary sulfides project in the stabilization agreement. This was to be found in the documents of the case. Specifically, as it pertains to me, in one of those meetings that I attended and the company was there, I said that if they wanted stability for the primary sulfides project, they could ask for the signature of a new stabilization agreement because there was a 2004 feasibility study. The DGM or the MINEM, did they ever confirm that the primary sulfides project could be included in the 1998 stabilization agreement for the leaching project? No. They didn't do it in writing, and it didn't do it orally, at least not in the meetings that I was there at. It's not legal. It's not possible. The regulations are very explicit. The mining regulations are very explicit when they say that, yes, there may be variations of the feasibility study without changing the subject matter of it. This during the execution of investment stage before the operation. As public officials, we went to the law, to the regulations, to have a clear position as to what is it that we had to do. Thank you. I have no further questions.
Well, pleasure to see you again. Good afternoon.
Afternoon.
Did you watch the testimony of Mr. Polo this morning or yesterday afternoon?
No, sir.
I did.
Did you transcript of the testimony of Mr. Polo from yesterday afternoon?
No, sir. I've just arrived.
I've just arrived in Washington, D.C. I arrived yesterday at 3 p.m., so I don't have a personal knowledge of that.
Did you read the testimony of Mr. Polo from yesterday afternoon or from this morning?
No, I have no access. I've had no access to Mr. Polo's statement or testimony.
In February of this year, you testified at the hearing in the SMM Cerro Verde versus Peru case, right?
That's correct, yes.
Did you review the transcript of that hearing?
My section, yes.
Did you review the transcript of any other witnesses?
No.
I did not, no.
Any other part of the transcript other than your testimony?
I've only read and had access to the transcript of my own testimony of February of this year.
And how many hours did you spend preparing for this hearing?
I arrived in here, I had 3 hours of meeting yesterday and 3 hours today, 6 hours.
With your counsel yesterday evening for 3 hours?
Yeah, in the evening, yes. In the evening.
Had another meeting with your counsel this morning for 3 hours?
Yes, at the lobby, yes, here.
And did you have any meetings, virtual or in person, with counsel before you came to Washington in preparation of this hearing?
Unfortunately, no. I've had no time available to hold meetings, in-depth meetings in connection with today's hearing.
No.
I haven't had any virtual communication. We had 2 video calls in the past, one in April and the other one last week for the final details of my trip, but nothing that was substantial.
So you mentioned you had a 3-hour meeting with counsel in the lobby. Are you talking about the lobby here?
Yes.
In the council room or where? Was it outside in the lobby, or was it in the party room, or where did you have the 3-hour meeting this morning?
El día
Today's meeting, I had a meeting with the lawyers at the Seedley law firm. I started at 8:30 sharp in the morning at their offices, and then after a half hour, we walked here and we had some conversations at the lobby of this building.
When you mean the lobby, you're referring to the waiting area outside?
Yeah, outside here on the ground floor of this building where all the furniture is, inside the building, of course.
In the waiting area or in the party room? In the open area or in the room where that is reserved for respondent?
In the open area where the furniture is and where you have the food there.
You're sitting there for how long? Prepping with your counsel?
20 minutes. I was sitting there, and I was also reading the printouts of my statements. I have them here. So I was reading those while I was outside here on the ground floor in the waiting room.
How many, other than meetings with counsel, how many hours did you spend yourself preparing for the meeting, reviewing material and the like? You haven't given me like a full number yet about
para esta
for this hearing, for today's hearing. Practically no time. I haven't had time in Lima to examine documents. The video conference meetings that I've held with counsel basically had to do with reviewing my arrangements for the trip. I haven't had a lot of time available, and the preparation, as you call it, was based on my reviews yesterday evening and what I did at the Seedley offices and what I've done today. So basically my written statement and the transcript of the February examination.
Let me follow up one more time on the prep in the open area because nobody saw you. With whom did you have that prep in the open area?
I arrived at 9:30 in the morning. Well, we arrived with Ms. Carolina Duran, the lawyer. We sat on those white couches next to the TV set and close to the window that faces the outside of the building. I don't know what else I can tell you.
How long did you, how many hours did you spend preparing for the SMM hearing? If I say SMM hearing, I'm referring to the hearing in February between SMM Cerro Verde and Peru, just as an abbreviation.
In the case of the February testimony, in February, I was in Washington 1 week before I provided testimony here and before the examination. I arrived here a week before, so back then I had more time than the time I had now when I arrived in Washington just yesterday.
You had preparation session with counsel every day during that week in preparation of the SMM hearing?
That's correct, yes.
How many hours did you spend in total, like for on this and the SMM Cerro Verde case, including the preparation of the witness statements, hearing preparation, attending the hearing?
I've never counted the hours, but perhaps I can do it now. So 5 hours per day for the February declaration, so 35 hours in Washington, plus the video calls in Lima, 2 or 3 hours, perhaps 3, so 45 hours in total. And for this statement today, I only had a meeting yesterday when I arrived in Washington, and I had a meeting today.
So that doesn't include the preparation for the witness statements, just to be clear, right?
It does not include the preparation of these documents.
And if you include those as well, how many hours approximately you would come to? You don't need to give me the exact numbers, but are we like talking in tens, like 60, 70, 80, 90, 100, something? If you can provide us with an approximate number.
8 horas.
Approximately 8 hours for each one of these witness statements. Approximately.
Statement.
Para cada una de ellas.
For each one of these, approximately.
And just to be clear, your witness statement, your first witness statement in the SMM arbitration and your first witness statement in this arbitration, the Freeport arbitration, they are almost identical, save for some very minor changes. Is that correct?
That is correct.
And the same is true for the second witness statement, right? The second witness statement in the SMM arbitration is almost identical with the second witness statement in this arbitration, correct?
That is correct, yes.
While you were preparing for the arbitrations with counsel, did any of the other witnesses participate in the meetings?
Are you talking about this hearing, today's hearing?
Oh, sí.
Yes. In particular, during the prep sessions, there was Mr. Cesar Polo, myself, and then later on, there were other individuals that came in that I came to know in February.
And these other persons that joined, they were witnesses in this arbitration, or?
My understanding is that they were involved in this arbitration. Many of them did, but I don't know what role they had.
And Mr. Polo and you attended together preparation sessions for the SMM Cerro Verde hearing, or for the Freeport hearing, or for both?
In February, we coincided in Washington. We were here a few days before. I arrived on a Thursday. I think he arrived on a Saturday. So we coincided at the same hotel and at the Sidley offices here in D.C. Sometimes we were reviewing documents in different rooms. Each of us was in a different room. And for this testimony, today's testimony, I have had a faraway contact with Mr. Polo today. I hadn't seen him before.
Participate in the session you had yesterday evening?
No.
He did not, no.
Did you have any sessions together with Mr. Isasi?
No.
I did not.
Did you have, other than preparation session with counsel, did you have any discussions with Mr. Polo about this case, either meeting him in person, or while you were in Washington here, or by telephone, or by email, or else?
After the February testimony, I met twice with Cesar Polo in Lima. We had friendly conversations, friendly discussions, nothing substantial in connection with these cases. Now, for today's testimony, I have had no contact with Cesar Polo, and I have had no contact with Mr. Isasi either.
And did you have any conversations with Mr. Isasi with regard to that case? Not, you said you didn't have any in preparation of this hearing, but before the preparations for this hearing, did you have any discussions with Mr. Isasi regarding this case?
No, I did not. The last time that I saw Felipe Isasi was via a video call at a meeting in late July 2022 when Sidley Council traveled to Lima. Before that, well, perhaps I saw him personally 3 or 4 years ago. Even here in Washington, I haven't seen Felipe Isasi.
So you saw the last time Mr. Isasi in a meeting that you had with Council for Peru in July of 2022, is that right?
It was a video conference. I was there in person at the Navarro law firm offices in Lima, in San Isidro, and Mr. Isasi participated at the meeting, but via a video conference link.
And what were you discussing at that meeting?
About the ways in which we had presented our first statement. From what I recall, they were letting us know that there was going to be a second testimony that did happen at the end of the year, and that's it.
You mentioned the student Navarro. Did Sidley participate at that meeting?
Yes. Maria Karina Duran, the lawyer, was there. She was there in person. Jennifer Howarth was also there, from what I recall.
Presencialmente.
In person.
Then the meeting in July of 2022. Did you have any other meetings with at which Mr. Isasi participated with respect to this case?
With me? No.
No, conmigo no ha tenido.
I have not met with Isasi alone or by video conference or together with the lawyers either.
So let me ask you whether Mr. Polo testified that he received a binder in preparation of the hearing, a binder of all the witness statements in this case and expert reports. Do you recall having also received a binder with all the witness statement and expert reports in this case in preparation of this hearing?
Yesterday at 7 p.m., I received a physical printed copy of my first statement and my second statement and the transcript of my testimony in February, and that was last night at 7 p.m.
Have you received a binder, physical or electronically,
I'm sorry,
of
but
all the witness statements and expert reports?
Solo las mías.
Only mine. Only mine.
Talking about
I'm sorry, Madam
any time
President.
before this hearing.
He's talking about Cesar's Polo testimony, and he should be showing it on the screen to him, because how can he know what he testified?
Sure. I thought you wouldn't like that, but I'm happy to do that. Can we put yesterday's testimony? I have it here as in Spanish as page 1314. It's tab 38 in your binder. Actually, 1313 to start with. You mentioned it several times. 38. Can we put it up on the screen?
Yes, we have just presented.
Oh, I see. Madam President, would you like us to introduce the transcript as a hearing exhibit, or are we fine using it as it is?
If Respondents' Council wishes, we can just produce it on screen, but we do not have to provide it as an exhibit.
Okay. Okay, it looks as though we are going to have to look at the physical copies. Do we have a printout for the members of the tribunal? Oh, it's in tab 38. So
Yes,
we're
and
gonna,
I recall.
yeah, we're going to have
what
to
you
look at
referred to.
the physical copies. So if you look in Spanish, it's 1313. Gosh, now I have to find the English.
Or what about that your colleagues
Here.
look for it and you jump to the next question and then
Okay.
we come back
Well,
so
I
that
was
you...
I was asked to show it. Here we have this. Here we have the Spanish, and I'm just going to read it into the record for translation. So at least it was here. The Spanish says, "Yo conocí lo."
I learned about the testimony in a binder that was prepared for the case, and I saw what their opinion was. Those statements I saw, but not all of them. I didn't read them all because it was overwhelming. I saw some, just those, and I got an idea. I have my own idea, and I thought that would be enough.
14, he says, I asked him, cuando usted dice que usted...
When you say that you reviewed the ISASI witness statements or the expert reports by the constitutional law experts, you did so to prepare for the other Cerro Verde hearing.
Para conocer.
I did it to take stock. They sent me all of the statements, and I thought that I had to review them. I reviewed my own in detail, of course, and a few more things. Nothing more, just to have an idea.
15, he again says, 315, line 18. Después
Then later we received them all. I imagine everyone the same. This is what I recall.
having read those, is it your recollection that you also received all the witness statements of all the other witnesses, Mr. Toa?
Let me be crystal clear. This statement by Cesar Polo from February of 2023, it's the first time I'm seeing it. I've never seen this, either a physical copy or...
From yesterday. And second, my question was whether you received a binder, be it physical or electronical, that has all the witness statements, including all the statements of Peru's witnesses and experts in it. Did you or did you not?
Mr. Dietmar, I want to know if you're referring to these statements of February, or, allow me, or if you are referring to the statements that I have cited, for example, in my witness statement, my written witness statement, which is in this other binder. So to answer you clearly...
Again, so I can make it clearer. I'm referring to a binder that includes all the witness statements that have been filed in the case, including Mr. Isasi's 2 statements, Mr. Polo's 2 statements, other people's statements who are witnesses and expert in this case. Have you received a binder with those statements before the hearing in February, or didn't you?
in April of my first statement. Well, I received, once it was, all it needed was to be signed, I received that. And with the lawyers, some parts of the statement were compared with the statement by Cesar Polo, and I did receive the digital file of the final PDF for Cesar Polo. I've also received, I'm talking about April of 2022 in preparation for my first witness statement. I also received a digital copy of the witness statements of some of the claimant's witnesses. I don't recall having received the digital file, but I did see in a video call, I saw and compared some paragraphs of the witness statement that had already been executed by Felipe Isasi. Then, when I got here to Washington in February, Sidley did prepare 2 binders of this size with many witness statements, and what they told me is, we've already given you all of this in digital form. So it was already reviewed. I never took it with me. So I hope that answers your question.
Well, partially. It raises a lot of other questions. So Silly told you that they had already sent you an electronic binder with all the witness statements and the expert reports, correct?
No.
No. I don't have expert reports. I have witness statements by the claimant that mention my name, and since they mention my name, I need to clarify whether the facts occurred as claimant witnesses have declared or not. Those I read. In particular, if I can, this of Ms. Chapuis, Ms. Torreblanca, I have received those in digital form. From Mr. Cesar Polo, the first in digital PDF. I don't recall the second one. In the case of Felipe Isasi, that was a topic of conversation in February here in Washington. I was never sent the digital PDF version, but we had a discussion of it in some video call, and it was shown on the screen. Expert reports, I don't recall having read them. Basically, my function, my role in this case is as a witness to recall and discuss the facts as they occurred.
Tobar, you testified, then when I got here to Washington in February, Sidley did prepare 2 binders of this size with many witness statements. And what they told me is we have already given you all of this in digital form. Do you recall having received the 2 binders with many witness statements in digital form?
I never did the comparison, but there was a binder like this. They weren't numbered sequentially, but with codes. But there were 2 volumes, Volume 1 and Volume 2, 2 different ones. I did not review them in detail. I just focused on studying and reviewing what I had signed, what my statement was on my own.
This contained the witness statements of Mr. Polo and of Mr. Isasi, correct?
No.
I cannot state for sure because I don't recall having reviewed those documents in print form. And in the particular case of Isasi, I remember clearly that in February there was a discussion that they had sent me the file, but I had never received it. Rather, it had been shown on the screen. And that is why mention is made in a footnote in one of my witness statements from the other case.
Let me come back to what you said with regard to Cesar Polos and Mr. Isasi. I'm going to take this step in step. So one thing that you told me is when you prepared your first witness statement, before you finalized it, you received PDFs of the statement of Mr. Cesar Polo. Did I understand that correctly?
Sí.
Yes.
Didn't you also receive the witness statement of Mr. Isasi on that occasion?
No.
I did not receive it. It was shared by the lawyers on some video call we had. Some paragraphs were reviewed. And I recall that video call because I said, look, something is mentioned there that I mentioned in my statement, and it was decided to put a reference as a footnote.
Well, I asked you, I mean, maybe we can just short circuit that, but do you recall that your witness statement in the SMM arbitration contained 5 footnotes citing to Mr. Isasi's first witness statement? Do you recall that?
Sí, señor.
Yes, sir.
And do you recall that your witness statement in the SMM arbitration also contained a footnote citing of your first witness statement citing to Mr. Bolo's first witness statement?
Sí,
Yes, sir.
And can you explain us why you removed those footnotes from your witness statements in the Freeport arbitration?
Yes. I thought they were redundant. They had already been used earlier. There was really no need to show agreement. Personally, I thought it was not necessary. But I do recall what you're saying. I thought it's not necessary, and so they were removed.
You said when you were preparing, you told me in the SMM arbitration, when you were preparing the first witness statement, it took you some time to prepare it because you had some problems recollecting some of the facts. Is that, do I recall that correctly?
Sí, señor.
Yes, sir.
And you also said that it was not, all the facts were not exclusively your recollection because after 17 years it is tedious to recollect some things precisely. Is that something that you would today agree with?
Es natural.
Naturally, yes.
You said because you had some problems recollecting the fact, counsel for Peru sent you a PDF of Mr. Bolo's statement. Is that still your recollection?
Yes.
And you said that you refreshed reviewing Mr. Bolo's statement. You refreshed your memory on some of the facts. Is that a correct statement?
I'm sorry, I'm confused about what you're asking him about. If this is about what he said in the SMM Cerro Verde hearing, he should be shown the hearing transcript as well.
I'm happy to. I wanted to short circuit it, but we can walk through the hearing transcript. So if you look at tab 3, that is Exhibit CE 1137, and that's a transcript of day 5 in the SMM arbitration. And in the Spanish transcript, it's pages 1389, line 14 to 1390, line 8, and in the English transcript, it's 1357, 11 to 1358, 3. Just thinks that was a mouthful. So I asked, my question was specifically whether you reviewed Mr. Bolo's witness statement before you drafted your report, since you cited in a footnote. Answer, not before, not before. And when the report was ready, when it was good and ready, that's when I had access to a PDF with Mr. Bolo's statement. So what I wanted to explain was that the reason I took more time to prepare the document, since I did so, I was consulting the lawyers permanently, and at the end I had access to a PDF file where what I remembered coincides with what the other person remembered. So indeed, in that point I say, yes, it was a coincidental opinion. I do not have a bad recollection that happened. It happened that way. You see that?
I'm sorry, I got lost. Can you show me exactly where you are reading from?
¿Qué página?
What page exactly are you reading from? Is it 1390?
1390 starts at line 22. And if you go,
Sí, es lo que dije.
is this 90, page 91? And if you then go to page 1391 in Spanish, line 5 to 17, that's in English 1358, line 19 to 1359, line 18, I asked you, you reviewed Mr. Isasi's witness statement before you drafted your statement or after you drafted your statement in order to see whether there was concordance. Answer, it was at the end, not before. I didn't review the words of other people. It is not my style. I prefer not to know, as I learned before. But in this case, I was taking so long that they offered me this possibility to say, you can check here, then it was this way and it was that. I was running out of time, so I submitted my final version. And if you go to the next page, in Spanish 1392, line 20, starting on line 20, and in English 1360, starting line 6. Question. When you prepared your second witness statement, we were talking now about the second one, and before you signed it, did you review again Mr. Polo's second witness statement and Mr. Isasi's second witness statement? Answer, the second statements, I think I did, yes, for my second witness statement. But I remember that the second one, the one that was prepared in November, September, of course, yes, mid-September, for that one I was just coming back from a trip, and yes, I did it, I did so. Yes, there was something of that, but I remember they were always PDF files, no Word. And this is when I was finishing my statement, I recall it clearly. Is that still your recollection today?
Yes, sir.
Okay. So you used Mr. Polo's and Mr. Isasi's witness statement to make sure that you had a coincidental opinion, as you put it, a concordancia.
Yo recuerdo haber
I remember having answered that specific question, and we have to be careful here. I don't base my statement on Cesar Polo's statement or on Felipe Isasi's statement. I wrote my statement based on what I myself remembered. It's just that once it was completed, drafted and ready to sign, a final review was conducted with the lawyers and points of agreement were found. And I said, well, it seems that we remember the same thing with respect to several things. But that doesn't mean that I based my statement on what I read of the other persons. That did not happen.
So the reason, to put it clear, the reason you weren't finishing, you testified that the reason you weren't finishing your first statement is you had some doubts about recollecting facts. And then Sidley offered you the witness statements of Mr. Polo and Mr. Isasi. And then you looked at them, and then you could suddenly recall the facts. That's what you were testifying there. Well, that was what I was just reading. So explain me how that could be interpreted in a different way, Mr. Tovar.
Mr. Dietmar, I wrote my witness statement alone, me, without consulting Felipe Isasi or Cesar Polo on anything at all. Now, once the statement was ready, the first and the second, in the final review of the document with the lawyers by video call, that is where, well, it seems that I've always been the last one to sign my statements. And when I was about to sign my statement, it was said, it looks like Cesar Polo remembers the same thing. We have the same memory. It's consistent. And that doesn't mean that I took Cesar Polo's document in order to then remember and have me write down my argument. I don't know if that clarifies things.
Sorry, Mr. Tovar, but any reason you didn't review them after you signed the statement?
Cuando ya firmo la...
Once I sign the statement, there's nothing more to be done. Why review them afterwards?
Mr. Tovar, in preparing your witness statement, you refreshed, I imagine you refreshed your memory also looking at some other materials. What documents did you look at? What type of documents? You don't need to tell me like the specific names of the documents, but what type of documents were you looking at, refreshing your memory for drafting the first witness statement?
The first witness statement, well, let's see. Having a direct memory of what happened 15 or 16 years earlier is not so simple for a regular guy like me. Some events I did recall. The times I went to Congress, where I personally defended the stability agreements vis-a-vis the requests of many members of Congress, many events. But if you ask me some specific question, I might say I don't recall. So if someone's signing, I'm referring to a claimant's witness. I had, as I explained in my February testimony, I had to go to the backup of information that I had from the ministry. When I left the ministry, I left a copy of the backup in the ministry computer, and I took a copy. Emails. I left to my advisor all the institutional emails. I reviewed these, I reviewed PowerPoints, I reviewed emails, and so on. And based on that memory, I drew up my first statement. The same thing happened with the second statement.
So, well, let me pick that apart, what you just said. You said when you left the ministry, you made a copy of all the electronic documents.
Not of all. Certainly, there are many that I did not take, but I made a copy of what I had in the computer.
Basically, made a copy of what you had on the hard drive of your computer in the ministry and took it with you.
Sí, señor.
Yes, sir.
And
Y dejé la copia en el ministerio.
And I left the copy at the ministry. It wasn't erased. And I explained to my successor, I'm leaving. Here are all the emails. Here are all the files, and so on.
The documents that you took, would you agree with me that they belong to the Republic?
I don't know how to answer that question.
Dora, you were...
Es una pregunta muy...
It's a very legal question. I don't know the answer at this time, to be honest.
The person in the ministry who, among others, was responsible, for instance, for granting beneficiation concessions, right?
Yes.
You received, for instance, a lot of information from mining companies about the technical specificities of their investments in order to determine whether to approve an expansion or the granting of a beneficiation concession. Isn't that true?
Yes, sir.
You're telling us you took all that confidential information with you. You copied that on your hard drive.
Well, you have to be careful with that. Excuse me. First, a lot of information that is provided by the regulated parties in that year, 2004, were not in digital form. They were in paper form. So anything that hadn't been scanned, I couldn't take it with me. This first. And second, by default, all of the information that comes into the state is public information. It's not confidential. Confidentiality in Peru has to be expressly declared. If there's information for a beneficiation concession, I don't recall that it being considered confidential. I don't know why you say it's confidential. I have not taken with me any quote-unquote confidential information in this regard.
So you're saying that for sure you received some electronic files, even in 2004, that refer to information that you received from other mining companies, didn't you?
Which is not necessarily confidential information.
No, I was asking you, you surely received some electronic files, emails from mining companies with information about the investment that they were making.
I am very careful in that regard, Mr. Dietmar. Information that is confidential and that I shouldn't have, I'd rather not have. Information that comes into the Ministry of Energy and Mines, even today, is not cataloged as confidential. It's public.
Whether you qualify them as confidential or not, I said, surely some of the documents that you had on your hard drive that you copied contained information regarding investments made by mining companies. Isn't that the case?
And it's public information, not confidential.
I'm not asking you whether it's public or confidential. I'm asking you that surely information on the hard drive that you took was information that you, among others, that you had received from mining companies regarding investments that you obtained in your professional capacity as the technical director of the DGM. Isn't that the case?
I would not say that, Mr. Dietmar, because all of the information that comes into the ministry comes in not to my email. It's not personally delivered to me. It comes in through the main channel. It goes to the secretary. It's assigned to an evaluating engineer, and then it comes to me on paper. And don't say...
I said, let me ask it the other way around. Sitting here today, you can say with certainty that none of the documents that you copied from your hard drive contained information that you had received from mining companies regarding investment projects. Is that your testimony?
Quisiera alguna...
I would like to hear something more specific because the question is too general.
I said, sitting here today, you cannot, sitting here today, is it your testimony that you can exclude that any of the documents that were on your hard drive contained information that you had received from mining companies regarding their investment projects? Yes or no? It's a very precise question.
I would say that no, Mr. Dietmar, because the documents were not given to me personally. They went through the channel.
The documents contained that information, or yes?
No
yes, you can exclude it, or no, I cannot exclude that possibility.
No.
I wouldn't be able to assert something like that.
15 years then, you testified in the SMM arbitration, you transferred the files on at least 2 occasions on new hard drives, is that right?
Es correcto.
That is correct.
And you also testified that in the process of transferring the files to the other hard drives, you believe that some documents might have gotten lost or not copied properly, is that correct?
Es correcto, es usual.
So yes, that is correct.
So I'm gonna come back to your to your hard drive, but you also mentioned that you were basing some of your recollection on notebooks that you were looking for, and perhaps we can again look at the transcript. That's CE 1137 in tab 3, page 1341 in Spanish, starting line 10. Is that? Oh, sorry, it's the English. 1341 in English, starting at line 10, and the Spanish is page 1372, starting line 16. And you let me know when you found it. I asked you, and did you, is there anything in the witness state, blah, 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 let me see. You mentioned, and again, having looked at old documents, I looked up my notebooks and I supplemented some things. And we have the Spanish here. And then you say, then I asked, so you kept cuadernos, notebooks from that period? Answer, yes. Well, I was able to recover the emails from the time, from the institution. And then I asked on page 1341 in English still, and those notebooks that you had, were they from the relevant period that you discussed in your witness statement, 2004, 2005? Answer, yes. These are notes that I had kept in my hard drive as documents, as notes which helped me. And then on a page later, on 1342, you said, I looked up my notes, my written notebooks. I actually didn't find my written notebooks, but I found notes, 8 memoirs in the computer. So having read that, I just wanted to confirm, because the answers were a little bit confusing. Did you have any written notebooks, as you seem to suggest in your first answer, from that period, or did you not have any written notebooks from that period?
Para clarificar
To clarify the answer and the logical sequence of the events, I am going to repeat this, and I am not going to read from what I said before. If someone does not have immediate recollection,
what you use them for. My question was, did you have written notebooks, cuadernos, from the time periods 2004, 2005, or did you not have written notebooks that you consulted? Did you have them? Did you not have them?
yes, I had them, but I couldn't find them for my first and second statement. Physical notebooks, yes. Yes, I had them, but when the case was presented and I had to look for older information to refresh my recollection, I never found the notebooks to date. I do not recall tossing them, but I couldn't find them. I haven't looked for them again either.
I was waiting for the translation. So just to be precise, when you said I had them, you mean you had them at the time that you were taking the notes, but you couldn't find those when you were preparing the witness statement in 2021, correct? Or whenever that was, 2021, 2022.
2022, es correcto.
2022, correct. In 2004, I did have notebooks. I made some notes of some meetings, some things, and when this case came up and I couldn't recall some events, I started to look for help as to recall this, and the first attempt was to look for my notebooks. I couldn't find them, so I started to look for digital information. I had some notes, and that's how I rebuilt my memories, my recollection.
And again, having looked at old documents, I looked up my notebooks and I supplemented some things as reading. You couldn't find your notebooks, as you later said. So you mentioned digital notes. What were those digital notes about?
Principalmente.
Mainly, they were emails.
You just said there were some notes in which you wrote down some things. When you said that, you weren't referring to some aide-memoires or digital notebooks, but what you mean is emails?
Fundamentalmente.
Mainly emails.
So in other words, you do not have any notes, like annotations that you wrote down, either in writing or electronically, of the events about which you testify. Is that the testimony? you were relying on emails.
Sí, señor.
Yes, sir. Mainly, I reviewed emails.
Mr. Praga, we do not want to interrupt you. It's just time for a break at some point. So
Yeah. No, maybe maybe just one question. And all the emails with which you refreshed your memory and you're relying on, you mention in your you identify in your two witness statements. Is that right?
That is correct, and it hasn't been because of a search. For the first witness statement, I look for my email. One doesn't preserve those emails, such as Cerro Verde Arbitration 2022. It is impossible to forecast the future.
I just wanted to confirm. So the universe of the documents on which you rely to refresh your memory is identified in a witness statement. Is that in the two witness statements? That's your testimony.
Sí.
Yes.
You relied that are not in your witness statement.
There are some pictures, photographs, basically emails, PowerPoints, that I also found them after looking for the emails, Excel, PowerPoints, but the source was to look into the emails.
Relied to refresh your memory, which you did not attach to your witness statement, that you do not mention in your witness statement. Do I understand that now correctly?
No, todo lo.
No, everything that I found I gave to attorney, and I did verify it and mention it in my statement.
To refresh your memory are in the witness statement. I'm getting
Sí.
different messages here. So
Yes.
El mensaje.
Yes, that is the message.
Ese es el mensaje.
Yes, that is the message. Gracias. Celebremos la pausa.
Madam President, before we start, if we could get an estimate of time, if at all possible, of course, just because we have another witness waiting in the lobby. So if we can release her or not, she will, of course, wait, of course.
Madam President, the other witness can go home, not home, but to the hotel. But there's an issue that I would like to raise without the witness being present. So if I could do that, please.
Mr. Tovar, can you please leave the room for a minute? We will call you in later. We have to discuss a procedural issue.
Madam President, we've heard yesterday and today shocking admissions of witness coordination, which are wholly inappropriate and unethical. And I just wanted to put down a marker and say that we claim and reserve all our rights with respect to that.
Does the respondent wish to comment?
We do, and we will, of course, need to address whatever arguments counsel put forward. At the moment, we don't understand what the shocking admissions are for us to provide a fulsome response. So at the moment, I would only say witnesses are sequestered from the hearing. They are not supposed to hear the testimony of other witnesses testifying before them, in particular their cross-examination. Witnesses are not sequestered from the moment they are being interviewed to be witnesses. They are not sequestered from each other or from anybody. They are not sequestered when they are preparing their witness statement. And we don't see why it is shocking that the witness, when he's about to sign his witness testimony, is shown a witness statement by somebody else to refresh his recollection.
Mr. Prager, do you wish to specify why this is shocking?
What is shocking is that witnesses were there are instances where witnesses were prepared together, where they were together in sessions preparing, where witnesses, in particular Mr. Polo, Mr. Isasi, and Mr. Tovar, coordinated the witness statements, such as, for instance, Mr. Tovar admitting to having reviewed Mr. Polo's and Isasi's statements before he signed his own statement, that they read the other witnesses' statements before the hearing. That influences the reliability of the testimony. Witnesses are not supposed to coordinate their testimony before the hearing. It's no longer reliable then.
May I? Madam President, there is nothing shocking about that. This is typical practice. I'm not saying this has been done largely in this case. I'm not talking about the facts. The facts are what the witnesses will say. So I'm not going here to testify about how the witnesses were prepared. Counsel is asking them. You have the facts. What I'm going to say simply is that counsel for claimant is not in a position to give us any reference to any rule that prohibits one witness, when preparing his or her witness testimony, to review the completed witness testimony, completed witness declaration of another witness, to refresh his or her recollection. If counsel gives us any rule, gives us a reference to any rule that prohibits that, and explains to us why there is a belief on the other side that witnesses are sequestered from the time they are identified as potential witnesses and shielded from the possible witness statements that others would prepare. If there is any reference to any rule, we would appreciate seeing it, and then we can have a substantive discussion. Thank you.
But I understand that you wish to take note of that, but we do not need to enter into further substantive discussion on this issue. Maybe it's also something that can be briefed in post-hearing submissions on the question of how much weight the tribunal is in one or the other suit to give to testimony, but I do not see any need to.
Yeah, I just wanted to clearly state our position and reserve our rights, but we can definitely and should definitely move on.
Do you agree?
I cannot disagree with the reservation of right. It's their right to reserve their right.
Yes. I think then we can call in the witness again. Welcome back, Mr.
Thank you.
Sorry, Tovar. It's late in this week, so we will now continue with the cross-examination.
Good afternoon again, Mr. Tovar. So from the hard drive that you described, you yourself reviewed it, searched for relevant documents, and then handed those to counsel, right?
Sí, sí.
That's right.
So for one of the time periods, as you know, that we are particularly interested in here is the time period from approximately June to October 2004. Would you agree with me? That's when Cerro Verde approached the ministry, had discussions, when a beneficiation concession application was filed and the beneficiation concession was approved, and in the meantime the reinvestment of profit as well. Would you agree with me that the time period June to October 2004 is one of the relevant time periods in your witness statement?
From what I recall, the contact with Cerro Verde in connection with reinvestment and beneficiation concession was January, February 2004, not October, January, February. That's in the documents.
Okay, so January to October. And you presented a total of 2 emails from that time period. And those emails are, we have them in tab 5. We don't have, if you want, you can look them up, but I'm not going to discuss the content of them. In tab 5, it's RE198. That's an email that we all know from Maria Chapuis regarding the meeting on a new stabilization agreement. Is this legal? And tab 6, RE199, which is an email from Ms. Chapuis to Cesar Polo, in which she says, among others, she won't participate at a meeting discussing the royalties. Those are the 2 emails that you identified from that period. Is that right?
Let me clarify something. You say that this talks about a new contract.
I'm not talking about the content. I'm just saying those are the 2 emails that you provided from your collection regarding the time period January to October 2004. That's the first one, and if you can look at the second one too.
Pero no habla.
It doesn't talk about a new contract.
I'm not discussing the content.
But that's super important.
And I'm asking you, these are the two emails that you presented with your witness statement regarding the time period January to October 2004.
Correct.
That's correct.
You have not presented any other email regarding that time period, January to October 2004, right?
I do not recall sitting here today. But these two that you mentioned to me, yes, I do recall those two.
Both of those emails you used to impeach Ms. Chapuis. On the one, regarding the first one, you say in the witness statement that she wasn't sure whether it was legal to include the concentrator, and the second one, you used that to show that she does not participate in royalty discussions, right?
That is correct.
So is it your testimony that you carefully looked through your entire files and that those happen to be the two only emails from the time period January until October 2004 that you could locate?
That is correct. As you can see, the subject line does not say Cerro Verde. So you have to look at each one of these using keywords such as SMCV, royalties, and Cerro Verde. So you can't really look at things in one fell swoop.
Mr. Toa, you would agree with me that the concentrate investment was a very high-profile case for the ministry in 2004, wasn't it not?
Yo sé.
I used those words here in February.
That there were several meetings with SMCV and Minim officials in the course of the year 2004. Isn't that right?
That is correct.
And you, Mr. Tovar, you reviewed and approved Cerro Verde's application for the expansion of the beneficiation concession. Isn't that the case?
To be more precise, I approved it in the second stage because there are three stages, or four. The first was the publication of the notices to modify the area. There's a signature there by Ms. Chapuis, the technical evaluation, and the approval of the technical review for construction to begin. That was signed by me, and then at the very end, the construction stage in 2007, I wasn't there at the ministry, that was signed by my successor and another Director General.
So you're telling us here today that you have not found a single document regarding any of the meetings relating to Cerro Verde at the time, except for the one where Ms. Chapuis says, is this legal? Is that your testimony?
And this one as well.
Yeah. So those are the two only regarding the meetings with regard to Cerro Verde.
In particular, this email does not talk about Cerro Verde specifically. If you look at it, it talks about its participation in general, the royalties law. At this date, 4 July, the law had been officially passed and published in the official Gazette of Peru.
Email regarding, sorry, I breached the rules here. You're right, you actually just presented one email regarding Cerro Verde out of the copy that you have from your hard drive. Is that correct?
There are other emails from 2005, 6 with presentations before Congress.
We're going to come to them. We are now in the 2004 time period. So during the entire application process of the beneficiation concession, you didn't find anything relevant in your document collection that would have refreshed your memory or that you... Nothing.
Nothing relevant. I cannot be an absolutist. I cannot say things absolutely. I have conducted a search during a number of days. I used a number of keywords and phrases, and whatever I found, I immediately sent to counsel by email.
So you're telling me that those are not the only emails that you found. You actually sent other emails to your lawyers? Not your lawyers, but to the lawyers of the Republic?
I've just mentioned to you that there are emails from 05, 06.
Are in 2004. 2004, okay? Are you telling me that in addition to those emails, you found other emails which you sent to that you thought might be relevant and that you used to refresh your memory that you sent to your lawyers?
I don't have top of mind a list of all of the emails that I've sent exclusively about 2004. If I found an email, I sent it right away. But if you want me to mentally go through a list, I can't do that. But I do recognize these emails.
But Mr. Tova, you testified before the break that all the emails you relied on, all the documents that you relied on, are the ones that you mentioned in your witness statement. That's the entire universe of the documents that you relied on for your testimony. And in 2004, we have those 2 documents. So you didn't have any other document from 2004 that you relied on for purposes of your testimony and what happened in 2004. That's right?
If we look at the emails one by one, I can confirm to you if that's what I found. But here, right here in my mind, I don't have them separated by month or by year. So if I take a snapshot right now without looking at any written document, well, there have been a number of emails that I have sent and found.
A statement in your first witness statement, Vice Minister of Mines Cesar Polo had clearly advised those of us in the DGM, particularly Ms. Chapuis, who was his subordinate, that the concentrator was not covered by the stabilization.
Excuse me, the interpreter was not able to follow that. I'm sorry.
I'm going slowly. You state in your first witness statement that, and that's in paragraph 14, the Vice Minister of Mines, Cesar Polo, had clearly advised those of us in the DGM, particularly Ms. Chapuis, who was his subordinate, that the concentrator was not covered by the stabilization agreement. You have not presented a single email in which anyone, whether it's Mr. Polo, you yourself, or anyone else in 2004, expressed any views about the scope of stabilization benefits, let alone their application to the concentrator. Isn't that right?
Let's recall that Cesar Polo, the Vice Minister of Mines at that time, well, we held meetings every Monday at 10 a.m. where we discussed important issues of the week, and I clearly remember that at those meetings we set the vision and the common sense related to the application of the contracts. Of course, Cerverda 2 was a high-profile agenda item, the primary sulfides plant, and I had to report on this, and I did it with the participation of all the mining directors. All of the meetings have been transparent.
While Cerverda matter that you had to report on, you did not find single documents about those meetings, about your report, nothing. It's just to confirm.
Cerro Verde was a high-profile project, so we always had the good intention and the good faith that the project was going to go forward, although the first environmental impact study of Cerro Verde had not been approved. So we had to show that the ministry was a promoter of investment. How is it then that the ministry is going to reject an environmental impact study, and then it can say that it's promoting investment? Now you're asking me about minutes or reports of these meetings every Monday. No, we never had that. We never had minutes of those meetings, of those Monday meetings. None at all.
Mr. Tovar, you started your work as the Director of Mining Promotion and Development in January 2004, right?
That's correct.
Comienzo de enero.
Early January.
Position within the Directorate General of Mining. Sorry. And that is a position within the Directorate General of Mining, correct?
That is correct. What's more, the Director General of Mining is the one who personally hired me.
And that was who?
Maria Chapuis. She was an engineer.
And it was the responsibility of the DGM to oversee and audit mining activities, right?
Just to be precise in my answer, the DGM had 3 directorates. One of them was in the Oversight Directorate. Mine was Promotion and Development. There was a third one that was Legal. There were 3 directorates.
Okay, so I'm going to come to them in a little moment, but I'm talking about the general responsibilities of the DGM. You would agree that the DGM was responsible for overseeing and auditing mining activities?
Es correcto.
That is correct, yes.
And the DGM was also responsible for ensuring compliance with stability agreements, right?
That's correct, yes.
The DGM was also responsible for granting and expanding the beneficiation concessions, right?
That is correct. We talked about a process for the new concession for new benefit or beneficiation concessions or modification of a beneficiation concession. I think the word expansion was just something that was understood, but what we wrote was modification.
To the structure of the DGM, like the 3 pillars. So at the top of it, Ms. Maria Chapuis was the head of the DGM, the Directora General of Mining, right?
That's right.
Then one pillar was the fiscalización, that auditing or the auditing department. The second pillar was, you mentioned, a legal department.
Sí.
Yes, yes.
And so the DGM had its own legal department?
Yes, that's right.
In 2004, do you recall who the lawyers were in that legal department?
Legal was known as the Technical Regulatory Office, and it was led by Ms. Rosario Padilla. She was a lawyer. There were 4 lawyers working at legal. Gladys Pastrana,
Wilber Esquivel.
Okay.
Esquivel, Cecilia Sancho, and Nicayo.
Lo que me acuerdo.
Those are the 4 that I recall.
Thank you. And the third pillar is the mining promotion and development part, right? And you were at the head of that department as the Director of Mining Promotion and Development, correct?
Yes.
And would it be fair to describe that department as sort of the technical engineering department as opposed to the legal one and the fiscal one?
Yes. But just to be more precise in my answer to your question, when Ms. Chapuis came in 2002, when she came to the DGM, she had the good judgment of organizing the professionals and the lawyers. In my area, there was one lawyer. Her name was Juana Menendez. She was the 5th lawyer. she reassigned all of the lawyers and placed them within the technical regulatory area so that we could have very clearly and pigeonholed departments. So all of the lawyers will be together and working in an orderly manner. That is what happened.
So in a colloquial way, your department, you were the mining engineering guys, right?
To answer that question, and I will answer your question, I have to share with you a recollection. In January, Ms. Chapuz said that all of the officials must have a copy of all the regulations at hand.
Whether in your department you were responsible for technical matters and it was mainly composed of mining engineers, right?
But they knew the rules, the regulations. That's what I wanted to explain to you. These are not engineers that ignored the rules and the regulations. They understood that to apply it to their reports.
And one of the responsibilities of the Mining Promotion and Development Department was to approve application regarding beneficiation concessions sorry, let me rephrase that. So one of the responsibilities of the Mining Promotion and Development Department was approving the application regarding beneficiation concessions from a technical perspective, right?
That is correct.
And the legal, I call it the legal department, the Dirección Técnica, etc. They would look at it from the legal perspective, right?
Yes, in a team as part of a process and not in isolation.
All the decisions that you would ultimately make, you would make as a team. The technical part, the legal part, the fiscalización, and ultimately the directora as well, correct?
Yes, sir. Yes, sir.
So let's talk about beneficiation concession. So you mentioned already that to operate a beneficiation plant, you need a beneficiation concession, right?
No.
Yes, that's right.
And let's say you have a mining company that has already a plant, a beneficiation concession with one plant, and now it decides to build a second plant. There are two possibilities. The first possibility is to ask for a separate beneficiation concession for the second plant, right?
Yes, sir.
And the second possibility is it could ask for having the plant, the existing beneficiation concession expanded to include the second plant in the existing beneficiation concession, right?
You're correct.
And there's some...
Doblemente correcto.
You're doubly correct.
Correcto.
Doubly correct because on the one hand, you have the two legal alternatives that exist, and also you mentioned twice that we're talking about a second plant. There were two different plants. The leaching plant, and then you twice said that we're talking about a second plant, which is the flotation plant for primary sulfides.
Companies that have built a second plant that requested a separate beneficiation concession for that second plant. And to give you an example, for instance, Tintaya requested a separate beneficiation concession for its leaching plant, right?
Cuajone and Southern with Toquepala. Southern with Cuajone and Southern with Toquepala.
Those companies have two separate beneficiation concessions. Each one has one plant in it, right?
Sí.
And in the case of
Yes.
in the case of Cerro Verde requested that its concentrator be incorporated in the existing beneficiation concession, right?
Yes, sir.
And if you have a common mining operation, like a mining unit, would you agree that it makes more sense adding the second plant that forms part of that unit into the existing beneficiation concession rather than having a separate beneficiation concession?
You're asking my opinion, or both options are equally valid? As I said a moment ago, they're legally valid, they're technically valid. They can be done. They can be done because the regulation allows you to ask for a new beneficiation concession, but it allows you also to modify the existing beneficiation concession. It doesn't restrict this. It can be a modification related to tonnage, surface area with additional installations. That may be the modification. So legally, it is valid. Now, who decides what's done? Well, ultimately, it is the investor.
If you look at the Cerro Verde beneficiation concession, that beneficiation concession, the DGM had expanded that beneficiation concession several times to include new investments, correct?
New facilities. And because of tonnage issues as well, as I recall now. So this coincides with what I said a moment ago. The modification of the beneficiation concession can be, first, because of an expansion of capacity, number two, because of new facilities. And if there are new facilities, well, ultimately, one has to broaden the surface area.
To the beneficiation concession, sort of that. So you're saying there are two parts of the criteria that you have to take into account for the beneficiation concession. One is I built a new plant, so I have to expand the geographical area, correct?
Sí.
Yes.
And the second one is I increase the output, a new plant increases the output, so the maximum output of the beneficiation concession, the metric tons per day of that beneficiation concession is increased as well, right?
That's correct, because let's recall what the law says. The law grants the beneficiation concession in connection with tonnage. Now, the mining concession is based on a surface area, but the law has provided, and nobody discusses has objected to this or changed this. Well, the beneficiation concession is granted on the basis of tonnage.
You mentioned that the Cerro Verde beneficiation concession had previously been expanded. Do you recall when that was the case?
Many times. It's happened many times. When I looked at the digitized copy of the file, I have found changes in the beneficiation concession area, perhaps twice. Before I got to the ministry, in particular in 2001 and possibly in 2003.
So let's just 1 second. Let's take a look at the approval of the beneficiation concession. And that the report is in tab 7, exhibit CE 476. Tab 9, sorry. All the tabs were updated since I printed out my outline. We can see the document on the screen here. Do you recognize that as the authorization for the construction to modify the concession of Cerro Verde processing plant?
Sí, señor.
Yes, sir. It's signed by me.
Okay, let's take a look at that. So the beneficiation concession has a title, right? It's called the Cerro Verde processing plant in English, and in Spanish it's called the Planta de Beneficio Cerro Verde. You see it here in capital letters and quotation marks.
Sí.
Yes.
And the authorization here is, if you look at the second paragraph, was to expand the capacity from 39,000 to 147,000 metric tons per day. You see that?
$147,000.
So the original capacity of the leaching plant was 39,000 metric tons, right?
Es correcto.
That's correct.
And then the concentrator was 108,000 metric tons per day. Per day.
Sí.
Yes. And the overall amount was 100. The newly expanded concession had 147,000 metric tons per day, correct?
Es la suma.
That is the two plants added together.
In your and the geographical area, we were also discussing the geographical area. Do you recall where it is located?
Sí, señor.
Is it located like at the mining site of Cerro Verde, or is the
Claro,
concentrator
están
located like outside of the mining area?
They're separate. They're not on top of one another in the same building. They're separate facilities. They're separate plants, as you yourself just mentioned. They're two processing plants for beneficiation.
All located within the Cerro Verde unit, right?
Físicamente.
Physically, they're around in the vicinity of the two open pits that Cerro Verde has to the north. Let me see, to the north. The leaching plant is to the north, and the pads were to the east. And primary sulfides, which is the concentrator, was to the northwest.
Location of the mining concession, would it be fair to say that the beneficiation concession for most part was located on top of the geographical area, was located on top of the geographical area of the mining concession?
Sí, pero.
Yes, but the overlap doesn't create any problem because they're two different rights. The right for the mining is different from the beneficiation, so there might be overlap, but there's no contradiction.
Let's just talk about the geographical location. Their mining concession is a mining concession. A beneficiation concession is a beneficiation concession. In your first witness statement, you try to distinguish between the two plants, and that's in paragraph 18 of your first witness statement. You said, it's going to be on the screen in a moment. In paragraph 18, you said there were two different plants in different locations with different headquarters that processed minerals differently and generated different products. Cerro Verde applied to build the concentrator in a new area as a new independent unit, so that once the concentrator would be installed, it would operate and process the respective ore separately from the leaching plant. Do you see that?
Sí, señor.
Yes, I do.
Now, when you say they were in different locations, you mean they were not located one on top of the other, as would be impossible, but they were located next to each other within the same mining unit, right?
Que acabo de
What I just said 2 minutes ago, yes.
You distinguish in your witness statement between the different processed minerals and the different products, but the ore was all coming out of the same pits, right?
And from the same deposit in different areas. Insofar as the ore is exposed, then the planning department decides what type of ore goes to which plant. And it's sent separately to each of the plants in order to carry out two separate independent metallurgical processes.
In different areas, but there wasn't one area of the mine where you could only mine the oxides, and there was another area where you only mined the primary sulfides. They were all in the same pit. You had both oxides and sulfides, right? Except that the deeper you get, the more you would come to sulfides, right?
When I mention different areas, I'm referring to the beneficiation installations. That is what is written. Now, if we look at the area of the pit, it's easy to differentiate the areas where the oxide ore is and where the sulfide ore is. They're not mixed. They're not mixed together. They're separated.
Look at the. Perhaps it's helpful if we look at a map of Cerro Verde, and we have that in tab 34, which is claimant exhibit 453. That comes from Cerro Verde's August 2004 presentation that you mentioned in your witness statement.
Pestaña número.
The tab number?
It's 34. It doesn't show us the geographical area of the beneficiation concession, but it shows us the geographical area of the mining concession. And it says Área Concentradora. That's the place where the concentrator is built, correct?
But in this image, you can clearly differentiate. I don't know if you have a laser pointer. I could explain to you where the sulfides concentrator is, the respective tailings dam, and the leaching area. They're not overlapped. There's no overlap. They're separate.
Concentrator on top of the leaching pads. They are separate, yes. But they are all within the same mining area, aren't they? And agree with me that once the ore is extracted from the pit, they are transported by the same haulage trucks, either to the leaching plant or to the concentrator.
It's decided at the pit, the decision is made as to where the material is going. It could go to the stockpile for the concentrator or to the leaching area. That's where the decision is made.
The ore is extracted for both out of the pit. That distinguishes Cerro Verde from Tintaya, for instance, where the leaching plant was only processing stockpiled ore at that time. Is that right?
I don't really agree, technically speaking, with what you've just said, Mr. Dietmar. The deposits are very similar. And the work of a mining engineer in an operation, it consists of identifying the type of material so as to send it to the appropriate destination. So I say this, and I must say it, because in the February session, perhaps there was some confusion that all of the material was mixed together and there was no way to separate it, but that's not how it works. That's not how mining works. The materials are separated, so much so that each shovel has a specific material in front of it that loads certain trucks that have a certain route and a certain destination. So one can clearly identify where each type of material goes.
Back to Tintaya later. So let's focus on Cerro Verde. The operations also share the same headquarters, right?
Sí.
Yes.
I think you said in your first witness statement that they had separate headquarters. Do you want to correct that?
Podría mostrar para.
Could you show it to me so that I could specify and explain, please?
You just said they have the same headquarters, right?
The offices, what are you referring to when you say headquarters? The administrative offices, the fields?
Administrative offices. So the administrative offices at the mining site were the same administrative offices for the leaching plant and the concentrator. They did not have separate administrative offices.
Yo personal.
Personally, I went to the site in September of 2004, and I saw it and visited there for the first time, the facilities at Cerro Verde, and there was a single building in which all the professionals were working. That was 2004. I don't know if subsequently other buildings were built or other offices. That I don't know.
Agree with me that the operations formed a unit, right?
Es correcto.
That is correct, yes.
And in fact, give me just one moment. And in fact, Minim recognized that Cerro Verde, the operations at Cerro Verde formed one unit, correct?
Well, they're in the same mining concession, in the same beneficiation concession. I don't recall any document that exclusively addresses what you've just said, but it's understood.
I'll show you an example, for instance. It's Claimant Exhibit 584, which is in tab 34. No, it's this. Sorry, tab 33. Do you know what the Anuario Minero Peru is?
Sí, señor.
Yes, I do.
Can you briefly explain what it is?
It's basically a summary, an annual report on what has happened in the mining sector the previous year, based on statistical information declared by the companies in respect of investment, production, and security.
Prepared by Minim, right?
Es correcto.
That's right, yes.
At the last full paragraph from the bottom here, we just have the Spanish, so I will read it in Spanish, so it is recorded in English. It says, Sociedad Minera Cerro Verde, con un...
Sociedad Minero Cerro Verde with an investment of 48 million in its EAU, Cerro Verde 1, 2, 3. Can you see that?
Quiero saber, no veo el año de publicación. Esto
Could you zoom out? Or I don't see the, to provide the context and the date. I'm not saying what's written here isn't valid. I just want to see the context.
Cover, and you were not at minimum. I just used this as an example. I'm not saying that you drafted it or anything like that. But it's a 2009 annuario, as you can see from the cover page.
es correcto, sí.
Correct, yes.
No reason to believe that Minim had a different view about the qualification of Cerro Verde as an economic administrative unit in 2009 than it had in 2004, do you?
No, but let's remember that these texts, these documents, since they're drawn up based on what the title holders declare, always have a summary paragraph that's very concise, very brief, that makes mention in summary of what has happened in certain companies.
Okay. Let me, I know we only have, conscious we only have 15 minutes left, and I think it's probably going to be unavoidable that I'm going to divide a line of questioning into interrupted by the weekend, but I also don't want to say that we should already break now. So let's get started, and then we can continue Monday. Let me talk about what is known as the roundtable discussions, and you will know what we mean with that. Let me just start that. Let's place ourselves to 2006, the year 2006. Okay. In that year, would you agree that Arequipa politicians were complaining that Cerro Verde was improperly benefiting from stability?
Mr. Dietmar, in my memory, the politicians have always complained about everything in my country. During my time at the ministry, it was always like that. They always went to complain. They weren't always right. Generally, they weren't.
But this was one of those instances. Would you agree with me that Arequipa politicians were particularly exercised about the fact that the ministry granted Cerro Verde the reinvestment of profit benefit that, you know, for short term created a budget shortfall, even though later on the investment would result in higher taxes. But for that moment, it created a shortfall of taxes for Arequipa. Is that your recollection?
I remember a lot that we were always getting complaints and grievances and shouts from the members of Congress, but we would explain what we had done. We would explain to them that what we had done was illegal, even if they didn't like it, and they would calm down. I remember this. This is what I recall.
You don't recall specifically that in Arequipa in mid-2006, politicians were particularly upset about Cerro Verde getting the reinvestment of benefit profit from Minim. You don't recall that?
I told you that generally speaking, I do. Of course I do.
General view about politicians, but I wanted to focus in particular now on the year 2006 and the Arequipa politicians. Now, you would agree that in light of that pressure, the government then formed a roundtable to find a solution to the claims of the politicians. Is that right?
Well, let me answer in two parts. First, there have been pressures, complaints, shouts, but MINEM never ever changed its position. Now, when I signed the report approving, I gave a favorable opinion on the reinvestment of Cerro Verde. I had to go to Congress to defend my position, and we never took one step backwards. We always explained, and Mr. Isasi was extremely didactic in explaining the legal issues. He would conduct a class.
I do want to advance, so please just answer my questions, and so that we can still advance a little bit before 5:30. So those roundtable sessions, they were organized in the within the Congress, right? The Peruvian Congress.
Sí.
Yes.
First such roundtable session took place on the 23rd of June 2006, right?
I recall that, yes, but before that there were meetings and visits that I made to the Congress in 2005, for example.
Now specifically about the so-called roundtable discussions which were organized by the Pro-Investment Commission in Congress, right?
Sí.
Yes.
Sessions was to bring the government, Cerro Verde, and the Arequipa politicians at the table and discuss the griefs of the Arequipa politicians, right?
As members of the executive branch, we had to sit very patiently to listen to all the complaints. The authorities, the mayors, are elected by the people, and the public officials no. So we had to listen.
Tamara, please try to answer my questions precisely and not with general statements. Can you just answer my question, which was those sessions were meant to bring the government, Cerro Verde, and the Arequipa politicians together at the table to discuss the grievances of the Arequipa politicians, yes or no?
That is what I explained, yes, sir.
In your first witness statement, in paragraph 66, you said that in those sessions in June 2006, MINEM officials gave a presentation in which they explained the tax regime applicable to Cerro Verde's projects and put forward the legal reasons why MINEM found that a company had to pay royalties in relation to the concentrator. You see that? That was paragraph 66 of your first declaration.
Can you show it up on the screen? I see. I participated in those meetings. That paragraph?
Testimony in paragraph 66 of your first statement was that in those sessions, MINEM officials gave a presentation in which they explained the tax regime applicable to Cerro Verde's project and put forward the legal reasons why MINEM found that the company had to pay royalties. That's what he testified in paragraph 66. Do you see that?
Yes, but paragraph 66 doesn't talk about the roundtable in Congress. Or perhaps I'm confused.
Let me just tell. So is your recollection today that at the roundtable discussions, MINEM gave a presentation in which they explained that the concentrator would not be covered by stability guarantees?
That is correct, yes.
And I think at the SMM hearing, you told us that that presentation was given by Mr. Isasi, right?
Sí.
Yes.
And how do you recall that the presentation was given by Mr. Isasi?
Mr. Dietmar and distinguished members of the tribunal, one's memory is sometimes a series of snapshots, and I remember that room. I arrived late, I sat by the wall, and I remember that I was watching from behind those who were sitting there. Well, I clearly remember Luis Carlos Rodrigo was sitting to the right of Mr. Benavente, but I don't recall having been seated making the presentation. And on occasion of this arbitration, having reviewed the documentation, including some of the documents the lawyers gave me, I saw the printed presentation, and I would generally bring the presentations printed out so as to be able to distribute them to the legislative aides. And when I saw it printed out with 2 slides per page, I recalled that that slide had the style, the didactic style of presentation of Mr. Isasi. Therefore, I concluded that it wasn't me who made the presentation, but Mr. Felipe Isasi at that meeting. And right thereafter, the impression that 10 printouts were distributed. And I remember that Cerro Verde made a presentation as well. I do remember that.
So let me understand whether I heard that correctly. So you looked at PowerPoint slides that you found. You said those PowerPoint slides have the style of Mr. Isasi. And from that, you conclude that Mr. Isasi must have given the presentation at the meeting?
Yes, sir.
You said you reviewed Mr. Isasi's first witness statement before you signed your first witness statement.
Correos electrónicos.
Emails. I discovered that reviewing emails, and when I saw the date, which was 23 June of 2000, well, when the roundtable was established, well, here it is, 23 June 2006. I was reviewing emails from those dates, and there was the back and forth of the versions that were reviewed with Felipe Isasi in order to bring to the presentation that day.
Tovar, you testified that before you signed your first witness statement, you reviewed Mr. Isasi's first witness statements. I will show you now his first witness statement, paragraph 65, that you must have reviewed. En primer lugar, here in Spanish, and the English is coming, he said, "First place, I must point out that although I know that those meetings took place, I do not remember exactly what was discussed in each of them. However, what claimant's witness asserts regarding what allegedly happened in those meetings makes no sense."
Párrafo
65 of the first witness statement.
Which paragraph?
Mr. Isasi, in his witness statement, did not recall what happened at those meetings. You see that?
Sí, señor.
Yes, I do.
Did not mention in his witness statement that he gave a presentation at those meetings. You see that?
Pero no.
But let's not get confused. He doesn't say that he didn't. He said that he didn't remember making a presentation.
Mr. Tovar, you see a PowerPoint, you explain. You say the PowerPoint has the style of Mr. Isasi. From that you conclude that Mr. Isasi must have given a presentation. Yet you review his witness statement, and the witness statement says, "I do not recall what happened at that meeting." Yet you testify in your witness statement that it was Mr. Isasi, sorry, not in your witness statement, you testified at the SMM hearing that it was Mr. Isasi who gave that presentation. You Is that a correct summary? And if not, can you?
Señor Dittmar, por favor.
Mr. Dietmar, could you please repeat the question? I got confused with your what exactly your question is.
You look at the PowerPoint to refresh your memory. You say the PowerPoint has the style of Mr. Isasi. You conclude from that Mr. Isasi must have given the presentation at the round table. You then look at the witness statement of Mr. Isasi, in which Mr. Isasi says, I do not recall what happened at the meeting. Yet you write in your witness statement, and yet you testify at the SMM hearing that it was Mr. Isasi who gave that presentation. Is that an accurate summary of what you just testified?
Mr. Dietmar, it is the same thing that I just said right now, that I remember having been seated at the rear, that it wasn't me who made the presentation. It was Mr. Isasi. I took the printouts and I distributed them to a person or some persons who had asked for copies. But I did not make the speech. I was not the one seated at the microphone making the presentation. It wasn't me. Or I don't remember it being me, because that sort of presentation, as appears in the back and forth of emails in the 2 to 3 previous days, were written by Felipe Isasi. Isasi said, I'm going to add this slide, I'm going to make an adjustment here. He was the one who was going to make the presentation.
Conscious of the time, I can make a break here and continue then on Monday morning.
And do you have already an estimate how much time you will need on Monday, just that we know when the other witnesses need to be available?
Yeah, not too much, because obviously we are running against the clock. I really would have to think about it over the weekend, but I would say a maximum of 2 hours, but I will try to have less. So certainly Miss Bedoya should be here by 10 o'clock or so.
Okay, any further issues to be addressed by claimant?
No further issues from us, other than to wish you a nice weekend.
Thank you. From respondent side?
Nothing on our side.
Then I take thank you. Yeah, then I take the opportunity on behalf of the tribunal to thank you very much for this week. It was a long week, and we wish you all a nice weekend. And you are released for today, and we will see you again on Monday. And I wish to thank also the interpreters and the court reporters. It was really impeccable what we received. Thank you so much.
Madam President, could you please remind the witness that he stays sequestered over the weekend?
This is again firmly understood.
Thank you to everybody. Thank you.